Can a co-trustee add a new beneficiary to a trust without the other co-trustee? Sounds a little crazy, but listen up because you're going to learn a few things. And keep in mind that in the question we were asked, the co-trustee added their own child as a new beneficiary. I am 𝗬𝗰-𝗬𝗰𝗍𝗂𝗏. We're an estate planning practice in New York and New Jersey. We provide peace of mind to families through our high client value services. We do offer free consultations for those here in New York and New Jersey who need assistance with their estate plan, or, of course, the administration following the passing of a loved one. We can help. The best way to reach us is at 𝗏𝑢𝑟planningattorney.com. And, of course, we are always here educating everyone on a frequent basis, so please ask questions and don't forget to share so together we can help some folks along the way. Now, a co-trustee can't necessarily just add new beneficiaries unless the trust document clearly gives that power. Okay? The terms under the trust really are the key to controlling what can and cannot be done and who the beneficiaries are. In this circumstance, they were talking about an irrevocable Medicaid trust. While often that term, irrevocable, to most folks sounds as if it means you can never change it. That's a little bit of a misnomer because there are flexibilities based on state law and also possibly within the document. But even still, changing of a beneficiary or adding a beneficiary is a pretty big deal. So you do need to look at those provisions of the trust, preferably with counsel, and determine if there's something in there, maybe like what's called a power of appointment. To be a little specific about that, it means that the trustee, if the trustee has that power, or even a beneficiary has that power, they can add a certain group of individuals to receive through those funds. Sometimes those groups are just designated as descendants, right? And of course, a grandchild in this circumstance would be considered descendants. Also, even though those provisions may be there, you have to check that first. You have to consider whether or not joint action between you and the other co-trustee, presumably your sibling, is necessary. Co-trustees sometimes are designated as required to act together, and if that's the case, they can't do that action without you. But also sometimes they're given the authority to act separately, with only one basically solidifying an action and following through with the power provided under the trust. Now, if it requires joint action and agreement, that person doing that alone is basically a breach of fiduciary duty. And if that's the case, the beneficiary, certainly you as beneficiary and co-trustee, could bring an action in the court to determine whether or not the other trustee needs to be removed, and obviously, adjusting the beneficiary designations back to what they were. So again, unless the trust explicitly allows for some flexibility in adding beneficiaries and you are determined to be co-trustees that must act together, then you might want to seek some assistance through court approval. Seek an attorney who does estate planning litigation in your area, and maybe see what next steps need to happen. You could also ask, of course, the attorney who created the trust just for some of these pieces, but if they're not helpful or seemingly, maybe working with your sibling, I would seek outside counsel. But certainly, I would just get some insight as to what the trust allows and how your sibling was able to do that. I'm 𝗬𝗰-𝗬𝗰𝗍𝗂, an estate planning attorney in New York and New Jersey. We always provide peace of mind to families through our high client value services. If you do need help with either setting up your estate plan or the administration following the loss of a loved one, we'd be happy to help. You can reach us at 𝗏𝑢𝑟planningattorney.com. Very much hope you learned something new here today. Please don't forget to share and take care. Bye-bye.